Many inventors and startup companies are filing a lot of patent application in the recent years. And after filing, they do receive an first examination report, which is an objection coming from the government. The moment they see this objection report or first examination report, many of the clients become panic or they get anxiety and they call and ask us whether my patent will get rejected. We need to understand something. If you receive a first examination report for your patent, there is no need to worry or there is no need to panic. Instead, we should understand that your application has been thoroughly verified and the government has asked for a clarification. In recent years, we are seeing that lot of first examination report has been issued and many of the clients are getting confused because of it on how to handle this. In this video, I'll be telling you about what is first examination report, why this examination report is issued, what are all the technical queries and legal queries which will be raised in this report, and how to handle these queries in a professional manner. All of these above points I'll be discussing with you. Myself Rohini, your corporate lawyer from Intelligensia Private Limited. Now let's find out what is an FER. An FER with respect to patent application is called first examination report. Whenever an inventor is filing a patent application, especially when he is filing a complete specification, the application will be published in journal. After published in journal, the inventor can file for request for examination. Once we file request for examination, the government will allocate a particular expert in that field of patent and ask them to examine it. The particular examiner will take the applications and thoroughly read through the same, and he will also make a prior art search and then they will issue a report. This report is called first examination report. Under this report, the following queries will be raised. There will be technical objections, there will be legal objections, there will be claim-based issues, there will be prior art references because government will also make a search, and lastly they will ask you to comply certain forms which will be a procedural forms. Whenever such report is issued, many of the client become panic and they become anxiety and they feel that the report is stating that your application is rejected. An FER means not rejection of patent. Whenever you receive an FER, that means your application has been thoroughly examined and now you have to clarify the doubts which has been raised by the government. Whenever the government is issuing this report, they will give you a stipulated time to reply to that report. If you do not comply to the timeline to submit the reply, then your application will get abandoned. Recently, we are seeing a trend where first examination report is issued in lot of applications. The reason for the same is government has given a provision for expedited examination for a particular patent, because earlier time it used to take nearly 4 years for examination of a patent, but with respect to fast track filing process, within 3 to 4 months the applications are examined, and many inventors are taking advantage of this fast track process. Do you know why? Because on everyday basis, lot of AI innovations are coming up. The nanotechnologies are getting updated on a regular basis. Also in biotechnology, we are seeing a lot of advancement and many startup companies are coming up with new inventions. Before the inventions gets outdated, many of them are applying for this fast track process to get the grant as soon as possible. Now we are going to see what are all the 5 important objections raised in FER report. But before going into that, if you are starting your business newly or you have started your business already, then we have a WhatsApp business community. In that community, we are clarifying your legal doubts as well as we are sharing the business development tips. If you want to join that link, the link is there in the description. Kindly click and join now. What objection usually comes under FER is the novelty objection. The examiner will actually take your application, thoroughly learn about it, and he will conduct a patent prior art search from the government end. And after that, they will quote all the similar patents and ask the actual inventor to give us the differences whether your patent has a novelty. So the first objection will be your application is not novel will be mentioned. Now filing the difference between the existing patents and your patent, you need to establish your novelty factor. The second objection is always the inventive step. The government is very particular about that any patent should not be a very normal or obvious invention. It should be new and as well as it should have a scientific step. So the government will always ask you to give a clarity on where is your inventive step and how can you give more clarity on understanding that part. This is called the inventive step objection. Number third objection is section 3 of Patent Act's objection, which states that your application is non-patentable. Now, if your application is merely a modification or merely a mixture of 2-3 elements, the government will consider that these are very known elements or these are something which is already existing, then your patent is not patentable. This is a common objection which will be raised across all the FERs. So for that, again we have to give a justification providing our inventive step and also giving a detailed clarification with the test analysis or any reports that we have. Number 4 is the claim issues and as well as the scope of the patent. Whenever you are using any other different words, which is a colloquial word or a market word in your patent application, the examiner will ask you to remove such names. And you might have filed 16 to 17 claims, but the examiners will say that only the first 7 points has novelty and you need to remove the remaining points. In such cases, you need to justify your point and remove some of the words and points which the examiner is asking you to do. And also you need to give a clear explanation for the following things in your report. The number 5 objection is one of the serious objection, that is insufficient disclosure. Whenever you are finding the term insufficient disclosure, then you need to become really careful and give your reply draft properly. Whenever we are disclosing our patent, we cannot disclose only one part of it and leave another part which the examiner may find out. The patent examiner and the patent office expects that your patent application actually mentions that how the invention works, what is the process applied behind it, what is the composition involved in it, what is the working principles involved in that, what are all the practical examples that you can give, whether you can give any test results or analysis or data that you have for this invention, and the implementation methods. If you are able to give all these 7 steps properly, then your examination report will not be a problem. But if you are going to leave any one part of it, then your invention will be considered as insufficient disclosure. Now we are coming to the most important part. This is the biggest mistake every inventor or patent applicants are doing every now and then. Whenever the first examination report comes, many of the inventors try to use ChatGPT to file a reply to the government. If you are going to do such kind of activities, your application will have high possibility of rejection. ChatGPT actually does not know what is the Indian patent law and Indian patent rule states. There are various rules which states that you should not use these words or you should not use the market based lines. So what happens is it has to be technical and legal document and not a ChatGPT based documents, and they will also verify whether you are submitting a reply using an AI. So all these kind of reply submission will be at a greater disadvantage for your patent. Now let me tell you, a proper FER reply requires the following 5 things. Number 1, a proper patent drafting skill. Number 2, a technical understanding. Number 3, a proper prior art analysis. Number 4, legal interpretation. Number 5, strategic claim amendment. In order to draft a proper FER reply, you need to hire a patent agent or a patent attorney. This will increase the possibility of grant of your patent. Now, what type of patent expert you should hire? Depending on the type of invention, you should be able to choose a patent attorney or a subject matter expert who is able to understand the technicalities behind your invention and also understand the report of R&D submitted by you. Now, after hiring a proper patent expert, you should also know how a strong FER reply looks like. In a properly drafted FER reply, a point-by-point reply or rebuttal should have been drafted. Any amendments in the specification or amendments in the claim should have been mentioned. A comparative technical argument between the similar patents and your patent should have been established. If you have any test analysis report, you could also add along with that. The goal of this reply is not just to answer the FER queries, but instead you should convince the patent officer to give a grant to your patent application. So as a patent applicant or an inventor, you should remember that FER is not a rejection of your patent. It means your application has been thoroughly examined and queries have been raised. If you are able to file the reply to all these queries with a proper legal and technical formalities, then your application will get successfully granted. If you are having a lot of doubts in submitting the FER reply for your patent, then in that case you can call to this number and get your consultation today. Like this, more useful video will be posted for many of the business owners out there. Kindly subscribe to our channel. Myself Rohini, your corporate lawyer from Intelligensia Private Limited.